How Nevada's court annexed arbitration program works. Well, in Nevada, all cases that have a probable jury award not in excess of $50,000 get shuttled into this arbitration program. It's not really all cases, it's all personal injury type cases, but if you have something different like probate or family law or class action, construction defect, those cases are automatically exempted from the arbitration program. So let's say you have a personal injury type case and it gets filed. The court will dump you into the arbitration program. You think your case is worth more than $50,000, so you can request to exempt it from the arbitration program. It's a written document you file, and you provide the reasons why it should be exempted, why the value has a probable jury verdict of more than $50,000. The other side has an opportunity to oppose that. And at the end of the day, the commissioner is going to make a decision whether it stays in the program or whether it's exempted from the program. So if it stays in the arbitration program, the next step is you're going to get a list of arbitrators. If there's only one plaintiff and one defendant, it's going to be a list of 5 arbitrators, usually. And each side has an opportunity to strike 2 of them, and then an arbitrator will get appointed from whomever's left. The arbitrator then will set a hearing date, and what will happen is both sides will meet with the arbitrator. It's often done electronically, not in person, and you'll hammer out the discovery dates, the rules, and also an arbitration hearing. So the arbitration hearing is typically 6 months from when the arbitrator is appointed. It can go out as far as 9 months, but if it needs to go more, there needs to be a showing of good cause. It's not something that happens every day. So when you first meet with the arbitrator, you're going to put out the parameters from discovery. It's usually brief. The whole purpose of the arbitration program is to make it quick and cheap. So you'll get limited written discovery, meaning one side's going to be able to send written questions to the other side called interrogatories, say, hey, answer these questions. You might send over some request for admissions, basically saying, hey, admit this, admit that. And then you can also send over a request for documentation. Of course, the other side does that back to you as well. Then there's also an opportunity for depositions. Usually the plaintiff gets deposed and the defendant gets deposed. Whether there's going to be an expert, whether some doctors are going to be deposed, that's all worked out at the time of the first meeting with the arbitrator as well. So once discovery is put together and an arbitration date is set, then the parties go to work. You do your discovery, you take your depositions, and then at least 10 days before the arbitration hearing or whatever the arbitrator decides, you're going to have to provide an arbitration brief. And the arbitration brief is going to be a list of the witnesses you're going to have at the arbitration and a brief statement about what they say. And it's also going to be a list of exhibits. And most times the parties are going to also provide arguments why they are correct and the other side is not correct. So once this is done, you go to the arbitration hearing. It is not at all like court TV. There is no judge in a black robe. There's no bailiff. There's no court reporter. There's no jury. It's generally the plaintiff and the plaintiff's attorney, the defendant and the defendant's attorney, and the arbitrator. And that's it. And often it's in an office. Sometimes it's even done virtually by Zoom or whatever kind of teleconference system they're using. And the way it works is the arbitrator will first, give a little description about how arbitration works, ask if the sides want to do opening statements. Because the arbitrator's already read about the case from each side and already knows what documents there are and already knows who's going to be called, oftentimes people will waive the opening statements. And then just like in real court, the plaintiff gets to go first. So if the plaintiff's got a lawyer, the plaintiff's lawyer is going to provide a quick synopsis of what's going on and call the first witness, which is usually the plaintiff. The lawyer will ask the plaintiff some questions to build a foundation for the case. And once the lawyer is done questioning the plaintiff, then the other side will have an opportunity to cross-examine the plaintiff. And this goes on until all of the plaintiff's witnesses have been called, which oftentimes is just the plaintiff, although there could be doctors, possibly a police officer, who knows. Anyway, the next chance is for the defendant, and the defendant gets to speak. And so the defendant presents the defense side of the case, often calls a witness, the defendant, and at the end of the defendant presenting witnesses and evidence, then the arbitrator asks if anyone wants to do closing statements, and that's just basically a summary of why your side's right and the other side is wrong. And oftentimes people provide a short synopsis, and then it's done. And so the arbitrator does not make a decision right there and then, although it's possible. Usually what happens is the arbitrator is going to say, hey, in X amount of days or a week or two, I'm going to get you this decision out. It shouldn't be 2 weeks. It should be less than that. And you're going to get a written decision. It goes to both sides. If both sides look at the decision and don't do anything, that becomes a final order and everything's done. If one side is really, really unhappy about it, unhappy enough to file an appeal, then the matter can be appealed, just like if you went to trial and you didn't like your verdict, you can appeal it as well. So that, in a nutshell, is how the arbitration program works in Nevada. There are rules to it. I will drop a link to the rules down below if you would like some good reading.